Well, welcome. It's terrific to welcome you to this Zoom event. A few years ago, we began inviting a giant of the bench or bar to offer reflections to the entering class, and it's been an extraordinary opportunity for our students as they embark on their legal career to listen to and learn from someone whose career has shaped the law. And first-year students, by attending Georgetown Law, you've chosen to learn in the place where laws are made. And this is evident in the speakers who welcomed our first-year students. So Justices Ginsburg, Scalia, Sotomayor, and Stevens have all spoken to our entering class. And today, we are incredibly fortunate to be joined today by Justice Breyer. So please welcome Justice Stephen Breyer.
Thank you. Thank you very much for inviting me. And thank you, Dean, and thank your staff, and thank all the students for coming. It's great. Nice to be here.
Well, it's terrific to have you here. So, one of the few advantages of the pandemic is normally seating capacity is limited to just our first year class, but we've been able to open it up to our entire community. So everybody has the opportunity to listen to this conversation. I also want to recognize at the start that this event is co-sponsored by the Georgetown Project on State and Local Government Policy and Law. We're joined by its Executive Director, Meryl Chertoff. So this event is going to be structured as a conversation. Most of the questions come from our students, and you can submit questions that occur to you using the question function. So, and I will try to answer or ask some of the questions that we get through the question function in addition to the questions that we've received in advance. So I know that for Georgetown law students, a long introduction of Justice Breyer isn't necessary, and as you progress in your law school career, you're going to be reading many of his powerful opinions and his dissents. But I'd like to just remind you of a few points about his background and his remarkable career. He was born in San Francisco. He's a graduate of Stanford, Oxford, and Harvard Law. Taught for many years as a professor at Harvard Law School and at the Kennedy School of Government. He was, after law school, a Supreme Court law clerk, clerking for Justice Goldberg, a Justice Department lawyer working in the Antitrust Division, an assistant Watergate special prosecutor and chief counsel of the Senate Judiciary Committee. He joined the First Circuit Court of Appeals in 1980, nominated by President Carter. And in 1994, he was nominated to the Supreme Court by President Clinton and was confirmed by the Senate. He's written books and articles about administrative law, economic regulation, and a book of constitutional law, Making Democracy Work, A Judge's View. And also, his most recent book is The Court in the World, which I had the honor of discussing with him at Georgetown's Bernstein Lecture in 2016. His wife, Joanna, was born in Great Britain, is a retired clinical psychologist. They have 3 children and 6 grandchildren. So Justice Breyer has had, as you've just heard, an extraordinary career, a great academic, a distinguished public servant, and a giant in the history of the court. And so members of our 2020 entering class, we can't hear you, but please join me in welcoming Justice Breyer. Welcome.
Well, thank you. That was a very, very nice introduction, I must say.
Well, it's, as we're starting legal careers, and that's what our audience is here, you really have had a remarkable one. So, it's great for them to be able to kind of listen to you and talk about kind of a career in the law and the advice that you had to give. But let me just actually start at the beginning. What made you decide you wanted to become a lawyer?
Well, none of the students will understand this, but if we go back far enough in time, you sort of followed what your parents suggested. Now that must be a foreign notion, but my father was a lawyer and he thought it would be a nice idea if I became a lawyer. And I thought, well, all right, I'll become a lawyer. And there we are. I'm sort of always interested, always wanted to do it, and I did. It's a very interesting field.
So it worked out. So it was a good thing to follow your father's.
No, but I mean, even there are so many possibilities in law. There's so many different possibilities. What I often say, and the more I'm in it, the more I believe it. I mean, the great thing about law is you need a head and you need a heart. If you're working for clients, you're trying to do something for them. You're trying to improve at least a tiny bit of the world often. And but everybody has a heart, but you're not going to do very well unless you also have a head. So it combines the two things. And the students here, we hope, indeed, we know pretty well, have both. And there are not too many careers where you can really combine those two things and go in all kinds of different directions.
So I want to talk about your law school career, and then I want to talk about, kind of how you thought of, what you wanted to do as a lawyer. But you went to Harvard Law School. What was your law school experience like? Did you like
it was sort of tough. I mean, the first year was not exactly, well, it was fun from time to time. Now, maybe there's an awful lot of law. And I used to think, well, what the law professors, of which I was later one, what we, the law professors and deans, have figured out is all these things you have to learn. Well, we'll get the students to learn them by announcing that they're learning how to think. Now, everybody wants to know how to think, but they don't necessarily want to know about the details of property law. So when we try to get them to focus on the details of property law, which I like, we say, now you're really thinking. Now you're really learning how to think, and then they really like it. But they do have to learn all that material. And there is a great deal in that first year and the second and the third of law school.
So now, so as they're starting their law school career, do you have any advice for them about being a law student?
Well, being a law student, you have to listen. That's good. That's good experience later. You have to listen to what the teacher is saying. And although people might not say it from time to time, it might help to listen to what your fellow students are saying too. And it's not just the teacher, it's a combination conversation. And that's very good. My father, who was a lawyer, you see, that's where he advised me what to do in the first year is each night read your notes. And on the weekend, read them again, quickly. And by the time you do that every week, lo and behold, exams will come around and you'll know it pretty well already. It's called reviewing, reviewing, reviewing. And that isn't learning necessarily how to think, but it is learning how to take exams. And that worked pretty well. But it's a very interesting law school. You have to know quite a lot. Think about what's going on in class, listen to what your teachers are saying, and go from time to time to a movie. I mean, don't forget it. And you are in Washington, and they have a great Shakespeare theater, and they have beautiful houses and some great gardens and museums and all kinds of things. So take advantage of that. Budget some time for it and go. The world isn't all law.
Did you see any movies when you were in law school?
Sure. I mean, and I still look, because I try to get my grandchildren to watch them. And they'll say, we don't want to watch a movie that's 80 years old anymore. I mean, it probably still is. It probably still is viewed as a pretty good movie, but Casablanca, everybody went to see Casablanca at that time, and I think they still do. And The Third Man, great Orson Welles movie. And if you wanted to see a foreign movie, my God, I saw it on an airplane about a year ago again, and it was still a great movie. Les Enfants de Paradis, Children of the Gods. It's about France in 1840, and it is a really good film, fabulous. Of course, that's just my own view. If you ask my grandchildren, they might say they have a great film, and in this film, the children all get caught in a video game. Oh, okay.
So are there one question that mine Aura asks is, what is one skill you wish you developed early on in your legal career that you found to be essential or at least very useful later on? So is there some skill that you would highlight that students should focus on?
Well, I think the skill for a judge and skill for a lawyer is something I've already said, and it's called listening. And listening doesn't just sit there and mean, oh, I hear what you say, but I'm going to forget it in 5 minutes. It means actually paying attention and trying to that's certainly true of teaching. My goodness. I mean, when you call on students in class and repeat what they said, as a teacher, repeat it in its best light, not its worst light. And then the student will know that you heard him, you've taken her in, and then you're going to discuss it, and some others will discuss it, and so forth. Exactly the same thing is true of the bench. I found when I was on the First Circuit particularly, if you listened and repeated back to the person, perhaps in the form of a question, what that lawyer has said, put in its best light, its strongest point, and then ask the other side, well, what do you think of that? Then both sides know you've listened to them. And the primary object of the judge is not to get everything right. That's impossible. What you're trying to do is to help resolve a dispute between people as best you can under the law. And you will do much better at resolving that dispute if both sides understand, even if you didn't agree with them, at least you listened to them and took in their argument. So I think that rates very high as a skill among lawyers. When you're negotiating with the other side, when you're trying to take some man came into your office, some woman came into your office, they have a problem. You're trying to deal with that problem, which may take the form of a dispute. You're not just trying to make the cleverest legal argument. You're trying to help that person. And I think that comes along. The lawyers learn that.
That's great advice. That's great advice. And, we don't highlight that enough.
Well, you can't. You're teaching them that 400 principles of property law. I mean, who knows where whatever it was, a use. What was it? It was a springing use, or it was a shifting use, or it was this kind of a life estate. I don't know. They've got to learn that. They have to learn it. That's what the property teacher is going to teach.
But I think, the 2 points, the importance of listening, and also just as a student, your father's advice about reviewing, because I think that's something that students, and I certainly never did that enough. You prepare for the next class as opposed to reviewing for the last one, which is so important.
Yeah, reviewing means it sticks in your mind. It means when spring comes around, or I don't know when you have exams now, you probably have them in December too. But 8 weeks before exams, or 6 weeks, you don't suddenly say, oh my God, what was he saying in September? What was she talking about in early January? Oh, I wrote this thing down here, but it looks to me like I was doing some doodling. I mean, what is that? So you'll catch that if you look at it the following Thursday or Friday or Saturday.
Yeah, and that's terrific advice. Ryan Polish sent in a question. What would your father think of your becoming a Supreme Court justice?
He'd be pleased. Now, he would be surprised. Indeed, my uncle would be very surprised because they didn't have many Jews when he was around. And my mother would be pleased, but she would not be surprised.
Now, did you always want to be a judge?
Most lawyers think it would be very interesting to be a judge. A judge, or a federal judge anyway, it's like lightning striking. And to be on the Supreme Court, it's like lightning striking in the same place twice. It just doesn't happen. And you learn that well, maybe you think you're qualified, but there are going to be about 10 other people who are at least as qualified. And then among that, it's a political decision by a political person, namely the president. And normally, we hope that it is in his interest to appoint a person whom the bar and others in the community will believe is a qualified person. But among 10 or 15 or 20, I mean, it's chance. Mm-hmm. It's chance, I think, from the point of view of the person being appointed. So, what should you do? Want to be a judge? I mean, do your job. That's what my father used to say. He'd say, do your job, do it as well as you can, and listen to other people. Mm-hmm. Now, that might lead you to a better job, one you like more, or it won't. Mm-hmm. But if it doesn't, you will still have the satisfaction of having done your job as well as you can. So it is a no-lose situation. And there's probably no better way to prepare to be a judge.
Mm. Now, you clerked for Justice Goldberg. Did that shape your idea of what being a judge is like, or what a judge should do?
It influenced me a lot, I'm sure. I mean, I've been very lucky in people I've worked for. I loved working for Justice Goldberg. I loved it. There were only really 2 law clerks in those days, and it was great. He was an enthusiast. He was fun, highly intelligent, and he took us to lunch all the time, which was nice for a law clerk. And I was lucky enough to work in the antitrust division for Don Turner, who was a teacher at Harvard of antitrust and really understood antitrust and brought a lot of economics in and was a very decent person. One stage of my career, I worked for Archie Cox, who was a totally honest man, a very competent man, but a totally honest man. And when he ran the Watergate, what he said when he gave a fateful interview after he was dismissed from his job, he said, I sometimes I think I'm getting too big for my britches. I wasn't here to get at the president. I was here to do a job, and everybody who worked for him knew that that was true. The facts fell where they might. And I learned a lot from Archie. He was a great man. And I worked for Senator Kennedy, Senator Ted Kennedy. And that might be the most fun I ever had. I loved that job. I just loved it. I like teaching too. But I mean, I rode a bicycle in, and I would get in on my bicycle and I'd ride in. So I was there at 7:30 in the morning, and it was just fascinating. And every single day, I guess you can't do that now, but I was chief counsel of the Judiciary Committee. Senator Kennedy was the chairman of the committee. Senator Thurman was the chief minority person. He was the head of the Republicans, which had a minority at that time. And every single morning, Emory Sneeden, who was a former Army general, JAG general, and I, and Ken Feinberg, who was on our side, he was a co-equal on the staff side, and the three of us would have breakfast. And we would discuss what was going to go on during the day. And the rule was no surprises, no tricks. We used to call that open conniving, openly arrived at. If we were conniving, we said what we were doing. And everybody knew we didn't like secrets. And I think it worked pretty well. The senators seemed to like it. It was called Doing Your Job. It was called the 12th grade civics text version of the Senate committees, and it ran pretty well. And things came up every 5 minutes, but it was a much easier to have a cooperative relationship then. And I love that job. I learned a lot from Senator Kennedy.
So, I mean, you've had a remarkable series of Justice Goldberg, Assistant Attorney General Turner, Senator Kennedy, Archibald Cox. I mean, you worked for a remarkable series of people.
I did. That's what I think.
Does that kind of, shape as a justice working with clerks, does that shape your idea of kind of the clerk justice?
Well, I quote them. My clerks made for me a coffee mug. And on it, they had printed the 8 things or 6 things or whatever they were that I most often quoted Senator Kennedy or the staff as saying. And right at the top was, what's he talking about? Meaning, Senator Kennedy would say, there's going to be this thing over here and you got to do that. And he was right. And then we had to figure out just exactly what he was talking about. But the things that were particularly useful would be, hey, work it out. Work it out. You're disagreeing with the Republicans on something, work it out. And that meant, in what I've said, it meant sit down and listen. And see if you can't figure out a basis for agreement so you can get somewhere. The other thing he used to say quite a lot, it's right on the mug. I mean, hey, credit is a weapon. Don't worry about getting credit for something. If you're working with other people on a project and it's successful, hey, there'll be plenty of credit to go around. And if it's a failure, who wants the credit? So I saw him quite often, and certainly we were supposed to do this, which we tried to do. I mean, you sit down with someone on the other side who disagrees with you, and you listen, as I said, and eventually he or she will say something. I say, maybe we could work with that. Maybe we could work with that. And indeed, you work with it, and something comes out of it. Maybe not exactly what you want, but he'd say it's better to get 30% of what you want And that's a much better thing than being the national hero among your own side and getting nothing. Okay? So I can't tell you how many times I would see him. If it was a success, he didn't get everything. He got some things. You worked it out. And there's a press conference to say, good, I'm glad you've got this bill through. And he would say, push out the other person. Push. Orrin did so much. Orrin Hatch was really helpful on this, you know? And he thought of this thing, and then we worked with that, and then we got the result. And that was Kennedy. And what he was interested was in getting something that would be helpful to people. And others disagreed about exactly what and so forth. Work it out. Try to do your best. Get 30%, get 20%, get 40, 50%. Great. You're never going to get 100%. You see? So and that's what went on there every day. And I grant you that was a different world. But my goodness, I really liked it. It was very, very interesting.
Is that, I mean, I think one of the things that's very striking to me was in your book, Making Our Democracy Work, you wrote, the court must help maintain public acceptance of its own legitimacy. It can do this best by helping ensure that the Constitution remains workable in a broad sense of the term. Specifically, it can and should interpret the Constitution in a way that works for the people of today. So it seems to me that there's a similarity between your judicial philosophy and kind of what you saw with Senator Kennedy. Is that fair? In other words,
certainly that's true. It's true to a degree that it's not, you just can't, choose a result that you like, and you can't just choose a result in a case that you think, well, this is workable. But I mean, there are many, many tools that you use to interpret a statute or the Constitution. You read the text, you look at the history, you look at the traditions. Suppose it says something like habeas corpus, that has a long tradition. You look at the precedents. You look at the purposes. Somebody had a purpose in writing these words. If it's the Constitution, maybe it should be called the values that underlie the First Amendment or the Fourth, which are different. They're different subjects. And the consequences, not any old consequence in the world, but consequences that relate to the subject matter, speech, say, if it's part of the First Amendment, or privacy, if it's in the Fourth Amendment. And some judges, all judges, use all those tools. They all use text, they all use history, they all use tradition, they all use precedent, they all use purposes or values, and they all use consequences. Some, like Justice Scalia, put more weight on the first four. He says, I just look at the text and the history and the traditions. We used to debate these things in front of law students and others, and we had a great debate in Lubbock, Texas, fabulous. And a lot of students came, and I was glad they did because they saw we liked each other. Mm-hmm. And I would say to him on this one, when we got to some points we disagreed with, you say you just use the first four. I just read an article you wrote where you said sometimes you do have to look at purposes. Mm-hmm. And sometimes you do look at consequences. And there are examples. And he said, well, I didn't mean 100%. And of course, I'll look at the text. Of course, if the text says fish, that doesn't mean a carrot. Mm-hmm. Okay? So all those things combined. Some put more weight on text, for example. And some, like myself, put more weight on consequences and purposes. But it's a question of degree, not absolute, not absolutely different philosophies. And often in constitutional matters, you want to look back to the basic purposes. And that basic purpose, which you see reflected in one phrase after another in that Constitution, is we are a representative democracy. We don't go out and vote like the Athenians, issue by issue, but we elect people, and they will make most decisions. And we will have now 330 million people living together peacefully. And that's what a lot there, you see, is in that word workable.
So is there an opinion that you've written that you're most proud of?
Hard to say. It's hard to say. You get a case and you think, oh, this is really a trivial case. What do I care? And then if you are a lawyer or you are a judge and you're immersed in a case, you know what you discover? If it's a trivial case, what do I care? You do care. You cannot help but care. That's the profession. And the longer you're involved, well, the more you see that that's so. So, for example, I was rather pleased with the dissent I wrote in a affirmative action case. I spent some time on it. I thought affirmative action is sometimes permissible under the Constitution. I spent a long time writing a dissent about the death penalty and trying to explain why there's a good chance it isn't workable in any fair way, and therefore we should reconsider it. So I was pleased with the work I put in on those. And I also spent quite a while working on a copyright case. And that was a fabulous case. Why? Because, well, the question was, can you copyright designs on women's dresses? These were cheerleaders' costumes. Or is that design a useful thing, which is not copyrightable? A very tough question, how you answer that. And before you know it, we were looking at lamps that had cats on them, and the cord would go up through the cat, and some wouldn't go up through the cat. And did that make a difference? And we had pictures of Van Gogh's Starry Night on a woman's dress. And it was a difficult case. Put a lot of work into it, as did my law clerks, and I was very pleased with that. You see? So it can range, hard to know. And which will turn out to be important, I don't know, nor really do any of us. I mean, history will decide that, and we won't be around. And after the historians get a hold of it, or if they do, if they're interested, sometime from now, years from now, they look back and read this and that, and then they write an article which shows that it was inevitable, which it wasn't.
So when Olivia Roach asks, during your more than 2 decades serving on the court, what has changed the most since you were first appointed, and how has that impacted your day-to-day work?
It changes. I mean, I've liked the people on the court. We've all got on well. In the 25 years, I've never heard a voice raised in anger in our conference. I've never heard one judge say something, mean about another, or not even as a joke. It's professional. We get on well. It's a different court with each new appointment. That's what Byron White said, and he's absolutely right. I mean, when I first came on, Sandra O'Connor was a good friend. Tony Kennedy was there, David Souter. And we tended to approach legal questions in quite similar ways. We might come to different answers, but we approach them in quite similar ways. They're gone. Well, that's the human condition. And so now it's somewhat more, I want to use, say, text, or I want to use this other tool to a greater extent. I don't know if what difference that ends up making. It's rather hard to say. I will leave to your faculty figuring that one out. But it is a different world. It is a different world, different people. It's a friendly world. It's a world where we are colleagues and get on, but it's different.
And do you think, are we going to see that as a trend over time? Is the kind of more focus on?
No idea.
Yeah.
I don't know. I don't know. And I do know that nobody knows. And the reason I say nobody knows, if they're anything like I was, and Souter was, and Justice Douglas or anything, and a lot of others, you get there for 3 years. The first 3 years, you think, oh my God, how can I do this? And then after 3 years or 4 years, or Douglas, I think, said 5 years, you sort of get used to it and figure you'll do the best you can. But you really don't know in advance. It takes time to develop approaches. Douglas used to say, well, after about 3 or 4 years, the basic themes begin to repeat themselves. So it becomes somewhat easier. Not every case is different, but it's a little different, but sometimes more different. But the themes keep coming back, and you've tried to think this through before. So people don't know. Of course, if you read, I don't want to be too critical of the newspapers, but if you read the newspapers, you'd think the decisions were all politics. That's not how it appears to us. I mean, I did work for Senator Kennedy. Politics is who comes into the meeting? Can you get a quorum? What's popular? Where are the votes? Senator, there's a call for you from the mayor of Springfield, and the Secretary of Defense is calling too. Who do you want to talk to? I know the answer to that. The mayor of Springfield. He's a constituent. I mean, you see, that's politics. That really is. And I haven't seen that. I don't see it. 40% or more of our cases are unanimous. The 5-4s, maybe 15%, 20% sometimes. Sometimes it goes up to about 25. Sometimes it's lower than 15. And it's not the same 5 and 4. It's not the same, even though you could say, well, these people tend to group together in terms of basic philosophy, or these others group. You could say that, but it's still not the same groups. I did look, I think a year or two ago, I can't remember the exact numbers, but I counted the 5-4s, and there were about 18, I think. Or maybe there were 20. And of those, I think 8 were what we call, from reading the newspapers, the usual suspects. And 12 were not. Now, I haven't done this experiment, but it's worth doing. Go back to the press description of those 12. I bet nearly all of them, the article would say, in an unusual lineup. Hey, an unusual lineup? How can it be an unusual lineup when, in fact, the unusual lineups are more than the usual lineups in 5-4 cases? But there we are. That's a problem. And the reason that that's a problem is the court at the moment, knock on wood, does have the confidence of this huge country of very different people with very different views. It's up there in the polls as to people trusting it, which is a very important and necessary condition for a rule of law. And undermining trust in institutions is a problem. And for us, from our point of view, if people think we're just junior league politicians, why would they do what we want? Why would we do what 5 people say? Why would we do what 8 people say? Why take any decision which I think may be wrong and follow it? And if that's your attitude, if people are not prepared to follow decisions which affect them, which are really unpopular, and which may be wrong. After all, somebody's wrong if it's 5-4. If they're not prepared to do that, there is not a rule of law. And that's what I tried to explain. There was a woman from Ghana who's the president of their court there, the Chief Justice. She's trying to put in more, human rights protection and so forth. And she says to me, well, why do people do what you say? And I went through a long history of stories, which is developing a habit, the habit of following it. But I said, the people you have to convince that they should follow, even sometimes a decision that affects them importantly, and they think it's wrong, and it may be. If they're not convinced of the need to do that, you won't have a rule of law. So don't have just the judges saying that, because everybody knows they're self-interested. And the lawyers won't work either, because they already believe that at some level they wouldn't be lawyers. It's the people in the villages, it's the people in the towns, it's the people in the cities that have to become convinced of that. And contrary to popular belief, 319 million of our 320 million people are not lawyers. All right? And they're the ones that have to understand the importance of that, or we don't have a rule of law. Some of the students, I will not mention what university, I could just tell because I was talking about Bush v. Gore. And I'd heard Reid say, hey, the most remarkable thing about that is never remarked, namely, it might have been completely wrong. I dissented, I thought it was wrong, and very important, but people followed it. There weren't paving stones thrown, there weren't riots, there weren't guns fired in the streets. And I could tell, I said, I know a certain percentage, I won't say what percent, are thinking, too bad there weren't some riots. Too bad there weren't a few paving stones. Too bad there wasn't a little bit of violence. Well, I said, before you come to that conclusion, go and turn on your television set and look and see what happens in countries that settle their differences that way. and then decide what you want. We know that. That's called the rule of law, our way. And I see that every day in the court. That's our most precious thing. It isn't one decision necessarily that we've recently made or an opposite thing. The most important thing to me is the fact that the people of this country, who are of every race, every religion, every point of view, every nationality, and my mother used to say that there's no point of view. So crazy that there isn't somebody in this country who doesn't hold it. We think all kinds of things, but these very different people have managed to live together for a long time now. We did have a civil war. We did have some real horrors. We did have slavery. We did have segregation. We've had a lot of ups and downs, but overall, ups and downs, but we've come out of it. We come out of it. We come out of the downs, and we still have this rule of law, and we still have our 330 million people of different opinions. And that, I think, is fabulous.
I mean, that's very powerful, and to highlight that, that the rule of law is really kind of at the core of the way we operate, and it's the core of our society. And it's interesting, many of the questions were about the politicization of the court. And I think what you're really highlighting is that, the decisions go both ways, and there's not a predictable lineup.
Hard to predict it. I mean, you can predict it if you know. I mean, look, I've been there for 26 years, I guess. And probably you or others have read quite a few of my decisions. Well, you get certain views, you get certain approaches. So if we have another case coming along, you might be able to predict how I would vote. That doesn't mean I'm voting politically. It means I put a certain amount of weight on purposes and consequences, perhaps more than Nino does. Nino he might have put more weight on text. Knowing that, you might be able to work out how we're going to deal with these constitutional cases. And if you have a statutory case, is the best way to figure out how a statutory case is going to come out? I tell this to the reporters. Read the briefs. You read the briefs and you say, how would I say it would come out? Not me personally, but I mean you, the reporter. That's not, none of these things always work, but they help. But predictability doesn't really prove too much.
Did you, I remember when Justice Stevens, I was at Fordham and he gave a speech at 30 years on the bench, and it was called Learning on the Job. And he talked about some of the important areas in which he changed his mind over the course of his tenure. Are there areas in which you've changed your mind, or is your jurisprudence largely what it was?
I think I've moved somewhat more because maybe I've just been forced to, but well, Frankfurter said that too, he said, start with the text. Don't twist the text. So what's twisting the text? You see, we had a case, I was alone. And I promise you the statute, when you read it, seemed to provide X. But I saw a real nightmare coming about in terms of the administrability of this very important statute, unless it was Y. But the first thing I asked myself was, does the text lend itself to interpretation Y? I thought it did. And I said, now look at these results that you're going to have if you follow X. Would I have put that at the very first thing when I first came? I wouldn't have thought it was necessary, but it is necessary.
And then
I'll tell you another way in which I think you change a little bit with experience is what I just talked about, the need for people in the country to live together. The need to try to get what law is after, a help. That's what my professors, Hart and Sachs, used to say. Law helps us, or is supposed to help us, live together in a society peacefully and with prosperity, get the benefits out of social living. Now that's highly abstract and highly general, but my goodness, I think that the more I'm there, the more important it moves towards the center of the case, that very general.
And are you influenced by your colleagues? So yeah, I think
absolutely. Nobody really wants to know. My mother would have wanted to But aside from that, I think nobody really wants to know what the Constitution is, according to Steve Breyer, or Sandra O'Connor, or Nino Scalia. They want to know what the Constitution holds, period. And the group that decides that is the Supreme Court of the United States. So let's try to get at least 5 people on an opinion. Let's do our best. And then you have a court opinion, and then judges and lawyers and others can plan their lives. Very, very, very important. And so recognize no one is going to get his way entirely, and often which there is no treatise on, which no one explains because it's so much internal as not just external, is to what extent can I accept something I don't really like? If you say, my God, it's terrible and I don't agree with it at all, you can't accept it. You know, but to what extent can we work something out here that I can live with? And maybe it isn't perfectly what I'd think, but it's close enough. And how do you do that? And when do you do that? And when, for example, suppose it's a fairly minor thing, as stay, or a case that's fairly minor, and you think, I really disagree with this case, forget it. I'll just swallow my dissent. David Souter used to do that every so often. They did it a lot in the 19th century. I'll just swallow my dissent. Forget it. The world will never know. Hey, the world will survive, never knowing. And when do you do it? When do you do it? No rule. Hard to say. You can't go too far if you think it's very important, but sometimes you can. And there are a lot of decisions like that for a judge, there is no book to consult. They're internal. Experience counts. Mm-hmm. And that's why I used to think, Michael Boudin wrote a good article on this in the Harvard Law School Bulletin. A good compliment for a judge or for a lawyer, that man or that woman reaches sound decisions. What's a sound decision? A sound decision is not necessarily a brilliant decision. A brilliant judge is fine, but that isn't necessarily what we want. I mean, what's sound? Being able to see how things will work for the future, having an understanding of how far to go, knowing when to compromise, understanding really, is this going to affect the life of another person and how? Seeing where in the thousands of different institutions, this will lead this person to do this and the other person to do that, and what does that all mean for our legal institutions as well as others? And there's no treatise, as I say, that tells you that, and you can only know a small part of it, and some of it is instinctive. You see? And there you are. That's what you're trying to do. And you're not trying to, well, I used to say this quote, hey, a brave decision. If certain newspapers write about what a brave dissent, I think to myself, I would have been brave if I'd written the opposite. It's not trying to agree with some other person. Tony Kennedy, should I go on here or have I gone on too long?
No, this is terrific. This is terrific.
Well, I heard him say, and I thought this was true, we had a group of Russian judges, and he was talking about judicial independence. And he said, well, in judicial independence, we have a guaranteed salary. And so they can't cut our salary. Ha, 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 try inflation. All right, you see, forget that. They can't fire us before we, or whatever. That isn't really at the heart of it. Because independence is really inside. You know if you're being independent. You know if you're reading that record honestly. Well, the lawyers know. Sure, the one you favor will say he's got it exactly right. And the one you disfavor will say he's got it exactly wrong. And only you know whether you've been honest to that record. You see? And what he said to the Russian judges is, we cannot sympathize with you in respect to a decision in any particular case. We don't know the cases you have. We know our cases after we read them, really talk about them and so forth. We don't know, but we can sympathize with the loneliness you may feel when you have a difficult case, and when you are trying to be true to that record, and when you are trying to be true to your thoughts, and when you are trying to be true to the laws, you understand it, and it's tough which way to go, and we understand that feeling. I like that. I like Kennedy when he said, Tony, when he said that, because I thought, yeah, that's right. That's right.
So one student question from John Lewis Overing, following up on that, what behaviors create the diverse collegial civic agreement and disagreement that you've talked about throughout your career?
Well, when I think about that, I think of my 5th grade teacher, Mrs. Squatagwatsa, because what she did was she had assignments where she broke the class into groups of 4 or 5 or 6, I forget. And you had to write a paper or do some kind of project, some kind of aspect of the history of San Francisco. And the key was, I think she used to give 1 grade to the whole group. All 5, all 6. Well, that produced a strong incentive to listen to the other members of the group. And it produced a strong incentive to compromise if necessary and get on. And I think that used to be anyway, and I hope it still is, all over the place in the schools. And we're supposed to be pretty good as Americans at being pragmatic and working things out. And we're supposed to know how to do that. And just get it done, figure out a better way. We have supposedly, even for very difficult problems, and we've faced a lot of difficult problems, ways of working things out. So what I tell the students on this is, say, first of all, you've got to know how government works, and that has to be taught. And you have to be taught what judges do and all the other people in the government do, and you have to be taught that in high school. So they used to have 11th or 10th grade civics or something. Where is it? Bring it back if it isn't there. And also, you have to participate. Participate. By that, I mean, of course, go and vote. Of course, try to convince other people politely of your point of view. Of course, be on the board of the library or the school board or the fine arts board or a neighborhood association that's trying to help others. There are hundreds of ways in a community in which you can participate, and do it, even though you're very busy. Even though you have 2 children and you also have 3 and you also have 4 and you also have 2 jobs, try to spend some time participating in public life in some capacity. And so you have knowledge, and you have to have participation, and you have to practice. I mean, you have to be out there, and that's why I'm so sorry that the number of school boards has fallen tremendously, maybe 20, 30, 40%, because there won't be that practice. Practice it. Practice getting on in projects with others. And the more practice, the more participation, the more you know about how government really works, the better our chances of having a government that can work for people. You want me to put that into tough? I read this in Derek Bach's book. Very tough to tell to the students. They didn't like this too much. But I read in Derek Bach's book on education, I think he quoted Pericles in his great funeral oration, talking about all the wonderful things of Athens. I don't know if he really said this or not. It's a good line anyway. And he said, you know what we say in Athens of the man who does not participate in public life? We do not say there is a man who minds his own business. We say there is a man who has no business here. Tough.
Yeah, that's. I think that's absolutely right. And actually, let me another question that I wanted to talk to you about. Last year's speaker was Justice Ginsburg, who spoke to the entering class, and one of the things she talked about was the way in which she talked about Justice Scalia and the way in which their disagreements made her opinions better. And she also said that you can disagree without being disagreeable. So, very similar about the importance of dialogue and, sharpening each other's arguments. Is there an anecdote about Justice Ginsburg that you could share with us as we remember her all the time?
No, I miss her.
Yeah.
And I thought of this, instantly, because I was actually at a religious service. I was actually at the Jewish New Year's, the Rosh Hashanah service, looking at it on tape at Central Synagogue in New York, not in tape, but in Zoom, with my daughter and grandchildren. And we had finished the service, and they were in the Kaddish, the prayer for mourning, the morning prayer for the dead. And at that moment, the telephone rang. And it was emergency, they said, so I had to take it. It was Marshall, and he said, Justice Ginsburg just died.
Mm.
So what went through my mind immediately? Great judge, woman of valor, a rock of conscientiousness, of decency, and a good friend. I mean, she was a good judge. She was intelligent. She worked very hard. She was interested in the detail as well as the overall thing, and I and others learned a lot from her. And she was steadfast, conscientious, but she was a very humane person. Look, just a few weeks before, I had another grandchild, and she sent out, without my saying anything, really, I don't know how she found out. She sent out to the grandchild the little T-shirt which said future RBG clerk. And then, knowing it wouldn't fit him, she wrote a little note which said, give it to your brother Ryan until you're ready for it. Oh, so she found out that he had a brother Ryan. And she did that a lot. Very nice, very nice. And I go back to my office, and there is a birthday card, which she'd sent a few weeks ago, and open it up, and it says, to my younger colleague. She underlined younger. And she was the kind of person that the more you knew her, the better you liked her. I mean, she wasn't going to be incredibly talkative if you're sitting next to her at a dinner party. That's okay. She would say something when she had something to say. That's unusual for me. Joanna said to me, I said this before, but she said, my wife said, Stephen, not every silence needs to be filled. That's something that I sometimes have a hard time taking in, hard time. She didn't, but a very, very decent person, you see. And my God, she and Nino really shared a great love of opera. And just a couple of weeks before she died, I called her, and I was trying to remember something. There was some opera about Boston that takes place in Boston. For whatever reason, I was trying to think. So I said, Ruth, you know what opera takes place in Boston? She said, it's Verdi. She said, a masked ball. I said, thank you. Thank you. She knew it. And I thought we had another question came up later. I thought I'd like to call her, but she's not here anymore. Mm. There we are. And there we are. So she will be much missed by me, by the others on the court, by everybody else too.
Yeah. No, it's really such a terrible loss. Such a terrible loss. And we all miss her very much at Georgetown. And then one question that one of our students asked that I also wanted to ask is, if, as they are first-year students, reflecting back, is there some advice that you would give your 1L, Stephen Breyer, about the future?
Calm down. The best advice I got about the future was from Bayless Manning, who was dean at Stanford years ago. Do you remember? Mm-hmm. He said, when you're worried about jobs, you're worried, he said, calm down. He said, when you make a decision, like what job you're going to take, you're only going to know at best about 5% of what you'd like to know and what you really need to know, but you can't. You can't know it. And so you'll choose. You'll choose on the basis of the information that you have. And I don't think you should be a tightrope walker if you're really good at law and not very good at tightrope walking. I mean, some things are obvious. But within a broad range where it isn't obvious, you'll choose. And then what will happen is your life will shape itself around your choices. I hope you'll be happy. I hope you'll have somebody to love, and I hope you'll have a job that you like, and I hope you will participate in community affairs. And most of that will be up to you. Most of it will be up to you, whichever of the choices in front of you you choose.
Well, that's a wonderful way to close. Very, very inspiring and thoughtful advice as our students start their legal careers. And I know that they're going to remember this occasion for the rest of their career. So you won't be able to hear the applause because we're all in our Zoom rooms, but I'd like to have everybody join me in a round of applause for an extraordinary conversation with Justice Stephen Breyer. Thank you so much, Justice Breyer.
Thank you.